Hi, I'm Mary Waltari of Battaglia and Waltari. I'm an estate planning attorney focusing on special needs trusts and conservatorships. We're going to talk for a couple minutes about conservatorships, or what happens when your child with special needs turns 18. As the parent of a minor child, you have the right to make all decisions for them. But once they turn 18, the law presumes that they're an adult. And so they have the right to make their decisions unless the court decides that someone should make that for them. That's a conservatorship. The conservatee is the person for whom decisions are made. The conservator is the person who makes decisions for them. The court decides whether they lack the capacity to make decisions for themselves, for their personal needs, or for their financial needs. The court also decides whether the conservator is an appropriate person to make those decisions for them. There's legislation which allows a limited conservatorship for a person with a developmental disability. And the goal is to grant them maximum independence and only take those powers that they're not able to independently exercise. There are 7 powers that can be requested. The first is to fix the residence or place where they live. Second is to access their confidential records. To consent or withhold consent to the marriage or entering into of a registered domestic partnership. The right to contract. To give or withhold consent to medical treatment. To control social and sexual contacts, and to make decisions concerning education. You should start the process when your child's 17 and a half, but if they're older, go ahead and start it. You can start at any time. The first thing to do is file a petition with the court and request any of the 7 powers that you believe are appropriate. You'll have to provide some personal information and background information about yourself. You'll also need to obtain a capacity declaration from the proposed conservatee's doctor. Regional Center is notified, and the Regional Center caseworker will provide a recommendation to the court on the conservatorship. Because the court will be taking away the rights of the individual, then that individual is entitled to an attorney. So the court will appoint a court-appointed attorney to represent them. If they don't have any funds, the cost of that attorney will be paid by the County of San Diego. That court-appointed attorney will come out and visit with the proposed conservatee and with you, and will make a recommendation to the court also on whether or not they believe the conservatorship should be granted. Generally, there's just one court hearing for a conservatorship. The proposed conservatee is required to be there. You should be there as a proposed conservator, and the court-appointed attorney will be there for the proposed conservatee. Generally, the judge does not ask any questions of the proposed conservatee, or they might ask them a simple question or two. If the conservatorship is granted, then you're giving letters of conservatorship, and this is what you use to prove your powers as the conservator of the person. If the individual has any assets of their own, you may need to also ask for a conservatorship of their estate. Once the conservatorship is granted, then there may be periodic follow-ups with the court. They may contact you every year or two just to check up and see how things are going. And you are required to let them know if something changes, if the conservatee moves, if you move, something like that. If you can't afford an attorney, then there may be an agency in your area that can help you with the conservatorship process. You can check with the San Diego Superior Court or also with the San Diego Legal Aid Society. But it is important to get this started. It's different for every person, every situation is different, so I recommend you get started right away. If you have any additional questions, feel free to contact me or check the website for additional information and resources.